In a 5-2 decision, it found the federal government overstepped constitutional authority and should be more cooperative with provinces in the future, something the Minister of the Environment and Climate Change says the government is committed to.
Now we will return to our homework and commit today to address this quickly and continue to make Canada an attractive and predictable place to invest in good, sustainable projects as we create and protect middle-class jobs and advance on a path of reconciliation.
The Impact Assessment Act received royal assent in 2019. It was meant to allow federal regulators to assess potential environmental and social impacts of resource projects. But it received a lot of opposition. In fact, the province of Alberta took the case to court, calling it the No Pipelines Act. It ended up in the Supreme Court last spring. The environmental advocacy group Eco Justice is one of a long list of interveners. Lawyer Josh Ginsberg says it's a disappointment. There's a great need for environmental assessments.
Some projects don't have their major greenhouse gas emissions assessed. That's a systematic problem. The decision refers to a certain Suncor project, which, and I have it here, is estimated to produce 3 million tons of CO2 annually. And the provincial process didn't assess it. The federal law was our only stopgap, the only thing standing between Canada and these harms.
According to the Minister of Energy and Natural Resources, the ruling doesn't mean the law is now off the books.
The federal government has responsibility in a number of these areas to ensure that our laws are protected. Like the Fisheries Act is a law. You can't just violate it because you don't like it. And so is the Species at Risk Act. And so the federal government continues to have a legitimate role with respect to whether projects move ahead.
Minister Guilbeault said the government would follow the court's guidance and work to improve the legislation through Parliament. Annette Francis, APTN National News, Ottawa.